for agreeing to conduct this session for us. This session is of special significance because we must all congratulate Professor Tiwari. He has just taken over the IPR chair at the university, and he's the first person to honor that chair. So a big round of applause for Professor Tiwari here. I made a monumental mistake yesterday. I asked him for his CV. I said, sir, I would like to introduce you. Could you please send me your CV? And since last night, I've been trying to read that CV. And I'm sorry, sir, 42 pages, good God, and 42 pages of such densely packed achievements. I have yet to see such a strike rate. So I am just going to stick to a few things. It's impossible to read out your whole CV. And I'm sure your presentation is just the tip of the iceberg of all the accomplishments that you have. Sir established the Department of Microbial Biotechnology at the Punjab University. He also established the DST Center for Policy Research. He also established the first incubator at Punjab University. And he's the one who got us the IPR chair from the Ministry of Commerce and Industry, Government of India. And he also got us the Technology Enabling Center that has been established by the DST at PU. And of course, he's been the Dean, Faculty of Sciences, Chairperson, Department of Biotechnology, and of course, not just Chairperson, Founder Chairperson of Department of Microbial Biotechnology. He's also been the Director of the Center for Industry Institute Partnership Programs, and he's also been the Honorary Director of CIL-PU. Above all, whenever he enters a room, he just lights it up with his presence and his learning. The moment you see Professor on a committee, you know that the committee means business. So this is the wonderful, constructive, positive presence we have with us today. I hope we all benefit from his learning. I'm sure he's going to put in his best to explain to us what IPRs are. Over to you, Professor Tiwari. Thank you very much for honoring us.
Very good morning, all of you. I don't know how many participants are there right now, but before I start, let me thank Professor Preeti Gupta. What she has told to you about myself, I'm just wondering whether I really deserve these kind of accolades. I just did my duty. I'm just I feel like an ordinary person, like who sincerely did something for the university. And I do feel happy and contented that I have contributed a little bit towards the progress of Punjab University. But the way Professor Deepti introduced me, I must say that this is for the first time that I feel that I have done something for the university. So thank you, Professor Deepti, for this. Now, coming to my talk, it's about a bit introduction or a primer to intellectual property rights. Let me first acknowledge I'm not an expert in this field. I have done something, I along with my scientific colleagues, in the domain of patents filed, granted in India and something like that. What can be done, some recommendations we have submitted to Government of India, how we can improve the patent ecosystem. So probably keeping these things in mind, Ministry of Commerce and Industry decided to establish a chair in Punjab University, and Vice Chancellor has been very kind enough to offer me, to nominate me on this position. So this I have with me a couple of my colleagues who are expert in this domain, and probably we can answer your questions to your satisfaction in the end. Now, as I said, this topic will talk about only the introduction, just an invitation to something, what it is all about. It's a public lecture, so there are people maybe of different streams who are listening to it. So I'll keep this presentation to very basic, essential things about intellectual properties. What do you mean by this? What are the different categories and all those things? We'll be talking more about intellectual property rather than the rights, because that's the domain of the Department of Law, people like to study law. So we'll briefly touch rights and then we'll talk about the intellectual properties. Okay. So we can start with having this word, intellectual property rights. It comprises of basically two major components, intellectual property and the rights. So the rights which are associated with intellectual property becomes intellectual property. Now, just to understand what is intellectual property, it's the combination of intellect and property. Property associated with the intellect. Now, this word property has a special meaning in terms of intellectual property, in the sense that we can divide or categorize property into two domains, tangible and intangible. Tangible is something which we can see, which is visually, physically present. And the example is of the land. We construct our house on the land, villages, they have their lands, agriculture land, people have farmlands. So this is known as a tangible property. We all are aware of this. But there is another word, intangible. Intangible means, okay, all right. So intangible means we cannot see. So the intellect, which we cannot see, that becomes your intellectual property. What do you mean by intangible is anything what we create involving our mind, including our brain, whatever we have an idea or a concept, we just try to convert it, translate it into some product or a process. So that product or a process is something novel which does not exist in the world. So the person who does this creation is the first one. So that kind of intellect which is used, this is in a property we call as intellectual property. Now I'll just give you a few examples of this intellectual property. It can be the domains of drugs or vaccines, your movies, songs, videos, architectural things, books and articles, dramas, craftsmanship, some products like Pashmina shawl, Kolhapuri chappal, basmati rice, beverages, plant varieties, and genetically modified organisms. So there's a large, big variety, or the domain is quite diverse of intellectual property. And there are certain rights which are associated with the intellectual property. These rights are nothing but the kind of incentives which are given to the holders of the intellectual property by the state government. State means nation or a country here. Each nation has some acts and laws which are dedicated to intellectual properties. So if somebody infringes upon the rights of the IP holders, we can take them to the court and they will do in the form of issuing some penalties, maybe imprisonment, maybe some kind of a fine. So these are all well-established things. Okay, now we talk about what is the need for these intellectual property rights. The major reason for having something for intellectual property rights is, or you want to have a monopoly, government provides a monopoly to the patent holders. It's for the reason that's kind of a reward for applying your mind to create something which is useful for mankind. Because a scientist or any person, any inventor, he has spent time, perseverance, he has conducted experiments, he has visited many places to get the data, relevant data. He has visited many libraries, historical places, experts, and all those things. Okay, so government, what it does is, when he has created something novel, so the government says, okay, you have this monopoly for a certain fixed period of time. That time you can sell this to the industry or for anybody for some cost. You recover whatsoever has been invested by you, and you make certain benefit. Thirdly, the need for intellectual property rights is the incentive part. It's a source of encouragement to the investors and the others to follow. If there is no incentive, I mean, why people who got permanent jobs, they should work, they know they'll get promotion with the passage of time, all those things. So we have these incentives in our all walks of life. Scientists, they all want to achieve a Nobel Prize. Film industry, they want to achieve Oscars. Many people, civil servants or in different domains, government awards, Padma Shri, Padma Vibhushan, all those big awards. And parents incentivize children right from the birth. आप ये काम करोगे बेटे, आपको chocolate मिलेगा, आपको book मिलेगी, and whatnot. Okay, so incentive is the one which keeps us driving to do something better for the society. Okay, now we talk about what are the different kinds or different types of intellectual property. Okay, first of all, you might have heard a few names like patents, copyrights, trademarks, industrial designs, geographical indicators. There is something in today's newspaper about geographical indicators. I'll discuss it later on. Semiconductor integrated circuits layout design. This is something you may not have heard of. It's quite recent. Plant varieties and trade secrets. So all the kinds of types of intellectual property, they are here. So briefly, I'll touch upon these, and then in length, I'll talk about for about half an hour on patents and copyrights. Now, patent is an exclusive right granted for an invention that generally provides a new way of doing something or offers a new technical solution to a problem. In layman's language, like you have created, you have invented something. Okay. Before I proceed further, there are a few definitions, some words like which are quite similar, which I need to discuss with you. Probably I will be using quite often in my talk. The first word is discovery, second is invention, third is innovation. Now we must distinguish between these three. Discovery is something like finding something which already exists in this world. Like Columbus discovered America. So America was already there. It just happened that somebody found it. Some botanists might find a new variety of a plant. Microbiologists might find some new microbe, maybe bacteria, virus, or fungi. So they come under the domain of discovery. Then you have invention. It's a creation of a new product or a process. Okay, so which never existed earlier on this earth. For example, Edison invented bulb, Marconi invented radio, and Graham Bell invented telephone. The number of examples. These are key inventions. And then you have the word innovation, which is improvement in an existing product or a process. So when you invent something, not necessarily this will have some societal impact. It is just something new, which is there. It might have some beneficial impacts, may not. So for example, if you are a chemist, you have created some 100 different molecules. One or two molecules might be of your interest that you're looking for something which can kill a bacterium, right? So he has invented all those 100 chemicals, but two of them to which you can assign a particular character that they have got the antimicrobial property and that can be used for curing an infection. This is known as innovation. Now, innovations can be as simple as a paperclip to a human robot. And it's not a Howard mouse, sorry, it should be Harvard mouse. It's a mouse which has been genetically modified. It has got certain cancer genes, and it's very helpful in studying cancers. Now, the patent is something now which we deal on daily basis. Day-to-day patented stuff is like pen, wristwatches, shoes, TVs, ACs, fans, toothpaste, mobile phones, cold drinks, juices, pizza, cars, scooters, snacks. So all these things, what we come across, majority of them, they are patented stuff. Now, the major characteristic of a patent is it is awarded by the government for a short duration, maybe for around 20 years. Information is in the public domain. So the government gives you a monopoly to exploit your patent for a fixed period of time, and in return they want that whatever you developed, this should be known to the public. But the public cannot use it, scientists cannot use it, though it is in the domain, because government has granted you the rights, the monopoly for that period. Unless and until the inventor transfers his rights to somebody, to a company, or sells a right to a company, they cannot use it. Okay, so this is your patent. We'll come back to it later on. Next is your trade secret. Now, this is also something, a confidential, a secret document of a company which will never come in the public domain. It will always remain a secret. Unlike your patents, it doesn't come with a fixed lifespan. It can be there for hundreds of years. Only a very few people in the company, they know how to prepare that product or a process. So there are advantages of trade secret, there are advantages of patents. We can talk about it later on. So I'll just give you a few examples of the trade secret. The most common is your Coca-Cola. Nobody has the recipe. Nobody, since for the over 100 years, nobody can make Coca-Cola. Still, it's a secret. Kentucky Fried Chicken. The recipe for Kentucky Fried Chicken is also a well-guarded trade secret. Google search algorithms. Now, you know, Google, so many, like you type anything, any word you want information, within seconds you get it. But the algorithms, the search engines, these things are very, very closely guarded secret. Then you have McDonald's Big Mac sauce. And there's another one, the last one, which is quite interesting, is your Angostura bitters. If you see, you can see the bottle of Coca-Cola, a bucket of KFC, and there's a bottle written as Angostura. This is alcoholic beverage, which is made in Trinidad and Tobago. These are Caribbean countries. It is so popular there. It is made with the plants and herbs which are grown in these areas. The secret is there for a number of years, or for over hundreds of years. And it's the major export item of that country. Now, if you look at the bottle, what you find is, look at the label of this bottle. It's an oversized label, though it has nothing to do with the trade secret, but there's a story behind it, like when 100, 200 years back, when they started making these alcoholic bottles, this alcoholic beverage. These labels, they were made in some different, by a different industry. And when they got it, they then realized, oh, the size doesn't fit. But they didn't have the cost for the new ones to get them replaced. So they just pasted these labels on it. And to the surprise, the public liked it. And still now, this label is being used on this. Okay, the third kind of intellectual property is your copyrights and related rights. Commonly, we just call them as copyrights. So these are the rights which are given by the law to the creators of the work. So I'll explain you what is work means. Work is not something what you just write on. It can be related to your literature, can be a dramatic thing, can be like I've just listed over here, sound recordings, artistic, musical, cinematograph films. So these all come under copyrights and related rights. We'll talk about it later as well. The fourth IP is your geographical indications. I'm sure all of us have come across this thing. Before I talk about it, let me just go to the next picture. Okay, let me just go back. Okay, let me just explain what is GI. goods as originating in a particular territory, region, or locality provided some or all characteristics of the product are attributable to its geographical origin. So what they're trying to say is certain product which has been that where it's localized to a particular region. I'll just give you an example. So like a Darjeeling tea, that you'll understand it better. So Darjeeling tea is grown in a particular area, right? It's been there over a number of years. So this comes under geographical indication. Then you have Pashmina shawls, okay, which are made in almost everywhere now, but their origin lies in Kashmir. The wool of the sheep, they use it for making these Pashmina shawls, okay. So GIs include your agriculture, natural and manufacturing goods. It can be given to an association person produced on, we can leave this thing. Okay, the validity is for 10 years. Now, the examples are Darjeeling tea was the first GI registered in India. The latest is Kashmiri saffron and black rice, which is grown in the northeast region. Now, this picture just gives you some more examples of geographical indicators. Kashmiri Pashmina is there, Lucknow chicken is there, Naga Mirch is there, Tirupati laddus are there. Then you have Mysore silk is there. So there are over at least 1,000 GI geographical indications. You just type GI India, you will get the list there. So these things, they are localized to a particular region. Now, if you have the plants used for growing this Darjeeling tea, you can easily grow somewhere else in India, maybe down south, maybe instead of Punjab. Okay. Still, you can label them as Darjeeling tea, but you cannot use a tag. Tag can only be used on the products by the people, by the industry who's making Darjeeling tea in that very region. Same thing goes for Pashmina shawl, Tirupati laddus, and all those things. So what I'm saying is anybody can make it, but they cannot use the label. Next is your trademarks. A trademark is any name, word, sound, numeral, color symbol, or drawing. This is used to identify goods made or services offered by a company or an individual. So this is self-explanatory. So we have the symbols of Starbucks, Mercedes, McDonald's, and Pepsi here, okay? And nobody else can use these labels except that very company. Then we have industrial designs. So what do you mean by industrial designs? It talks about the external shape, configuration, surface pattern of an industrially produced article. Like Coca-Cola bottle, in the picture you can see Vespa scooter, camera, juice extractor, rocking wheelchair, iPad or iPhone, okay? So it's a non-functional entity, but this structure or 3D structure, it cannot be copied by anybody else without seeking the proper permission of the ones who hold the rights. Plant varieties talk about all the different varieties of the plants. I mean, let's not go into the details about this. Similarly, the last category of IP is your semiconductor integrated circuits layout design. Primarily, we're talking about the chips. This is the era of, it's a digital era. Information technology, computers, they are everywhere. So all these things, they are being made by some chips, which have got these circuits, right? Even now in automobiles and scooters, wherever, in our every walk of life, we have these circuits. So each nation has carved out a special category of IP for these, which is semiconductor integrated circuits layout design registry. Okay, now we shift to, we'll talk a little bit about the patents. The first thing comes is, okay, so you have invented something, you developed it. Now the next question is whether you really want to patent it or not to patent. Let me put it other way. A scientist looks from a different perspective. Small percentage of scientists, I would say now, in the present era, what they say is they have invented something with the public money, whatsoever resources, funds they got from the government, they created something. So they feel that this should be given to the public. They do not want to get any financial gain out of this. The number is very small, but I'll just give you one example. It varies from person to person. One American by the name Norman Borlaug, he was an agriculture scientist in America. This man is a Nobel laureate. He's a Nobel laureate. He has created number of varieties of wheat, barley, rice. In 1960s, what happened? There was a big famine in Asia, including India, Pakistan, Bangladesh, and in South America. It was believed that close to 1 billion people will die of starvation. This was in 1960s. But with the intervention of this man, with the inventions of this man, he created some varieties which were very high yielding, which were resistant to droughts, which were resistant to pesticides, and free of cost, he distributed it to everybody. He did not give it to any company. So here is an example that there are people who do inventions, but do not follow the path of patents. Though the number is very minuscule these days. But now, okay, so you have an invention, you want to patent it. Then the terms is, okay, you want to patent it, what in return, what kind of rights you're going to get? A patent owner has a right to decide who may or may not use an invention. In other words, patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without the consent of the patent owners, because he has a monopoly. That's the right he gets. Now, for your invention, you want to get a patent, but there are certain conditions which necessarily you have to meet. Only then the patent would be granted. There are 3 major conditions. The first one is the novelty. What we call as novelty means not part of the state of the art. What does this mean? That for your product, what kind of information related to that product is available in the public domain, in the patent domain? That a scientist has to find out. Only when he is convinced that his product or process is novel, it has not been reported earlier, so then he meets the first quality of novelty. Second is the inventive step. So whatsoever invention he has done, so that invention should not be obvious to a person skilled in the art, in that particular field. So if he says he has done invention, say in the field of microbiology, suppose I'm a microbiologist, I'll just give you a small example. Everybody we make curd at home. Curd is made with the help of microbes. All of us know, we know that, right? And we also know that making curd takes less time during summer period vis-a-vis in the winter period. And we all know it's because microbes, they are very active at high temperature, and their activity gets slowed at low temperatures. So that's why it takes less time. It takes more time in winter to make a curd. Now, this thing is known to a microbiologist. So if a microbiologist says, okay, I'll use now, instead of 35, I'll use 38 degrees to make the curd, this will still lessen the time. But this is very obvious to a microbiologist. So that kind of incremental, very small, tiny incremental change will not pass the test of inventive step. Thirdly, whatsoever has been invented, it should have a commercial application. It should benefit the society. So these 3 are obligatory. And the third one, which is also very desirable, is the invention must be disclosed in the application in a manner sufficiently clear and complete to enable it to be replicated by a person with an ordinary level of skill in the relevant technical field. So any ordinary person with a little bit of skill can duplicate. So what we do is now, how you obtain a patent is you have to file an application. The application forms are available with the Indian Patent Office. So you take out the requisite application, you fill it. It's very complicated for filling an application. And a person who is filling it for the first time, I can bet it, he cannot do it on his own. So you need to hire an expert, a patent attorney for this. Okay, once you have filed and they fill all the columns, you submit to the office. Then office, what it does is it publishes the application in the journal, in the official journal, which is published by the patent office. So when this is published in this patent journal, then for a fixed period of time, they wait so that if anybody, now this is in the public domain, people would read it, scientists would read it, and if there is any objectionable, then they submit their objections to the patent office. So the patent office then talks to the person like who submitted the form, and if they are satisfied that the objections are not valid, then they proceed further. Next step is your patent examination. There are specialists or examiners in the patent office who seriously look at the application from those 3 points: the novelty, inventiveness, and the application part. So this is a very serious business. It takes time, and there are a number of queries. Generally, they are raised by the examiners, which the patent holders, the applicant, sorry, they need to answer. So once the examiner is convinced, only then the patent is granted. Right? Now, this is the brief story of the steps involved in the patent application process. But the one thing which is important for filing an application is prior art search. Without doing this word, I'll explain you what this is. You cannot submit or fill the application. Prior art search, what does it mean is that you have done this search. The relevant data which I talked about earlier is relating to your invention. So you look at the various their patent databases, which I've just listed here. Some are paid, some are not paid. And in addition to patent databases, there's a word known as non-patent literature. So you have to look at that also. I have not included there also. But this has to be done. This is a massive exercise which the applicant or applicants, they have to undergo. So prior art search has a special meaning. It's very important for the filing of a patent. Okay, once the patent has been granted, then the first thing comes to your mind is, what is the longevity of the patent? So generally the patents are given you for 20 years. So 20 years is a reasonable time in which they can recover the investment which have been made, and you make a little bit of profit of it. So once this 20 years are completed, then your patent is in the public domain. Anybody can use it free of cost. Now, is it possible to extend the term of patent protection? I'm just time, so let's see how we do it. Is it possible to extend the term of the patent protection? Yes, in some countries, extension can be given. But there has to be a sufficient logic behind it. Most of the time what happens is the extension request aims to compensate for the time expended on the administrative approval procedure before products can be put in the market. I'll give you a practical example. Let's say, for example, vaccines. Okay, so you file a patent, you granted a patent within a couple of years, but then there are regulatory bodies. You got to do some experiments first in the lab, then in the animals, then in the humans, then in a population. Only then, when you have cleared all these steps, then you can bring your product or vaccine in the market. And by that time, you might have used 10 years, 12 years, 13 years. So your window of exploiting your patent becomes very less. And it takes millions and millions of dollars, hundreds of millions of dollars, to have a vaccine in the market. So these days you can very well understand everybody is after the coronavirus. So there was a news, ICMR wants the scientists to give the this product by August 15, which is practically not possible. Any biologists know it. It is practically not possible. Not possible because they have to do those experiments. Okay, the time taken for this procedure means that the patent owner may sometimes not be able to benefit from the right. Just explain that. Okay, so once you have the patent, another term is patent licensing. Okay, so normally patents which are the holders of patents are maybe a scientist in the research lab, maybe a professor in the university. So they have their permanent jobs and they're good at it. Marketing, commercialization, scale up, they are different domains. So what they do is then they say, okay, so we will sell it. This selling of patent is known as licensing. Okay. So a patent owner may grant a license to a third party for many reasons. Patent owner may not have the necessary manufacturing facilities, or he has the facilities but may not be large enough to cover the market demand. Patent owner wishes to concentrate on one geographical area, say like one country, India, and for other areas, for other countries, then he licenses the patents to other people. This one in the red we can skip. I'm just looking at the time. Okay. Now this thing was important.
Sir, don't worry about the time, sir. You can continue at your own pace.
Okay, thank you. Thank you. Okay, so next question is, can an invention be patented after publication? This is for my colleagues in the universities, in the colleges, in the research labs. So they have to be very clear about things. Publication and protection, they don't go together. They don't go parallel. If you publish, then the chances of getting a patent becomes very, very low. But if you have patented first, then you can publish. It is possible. So most of the time, scientists, they have wonderful discoveries, wonderful inventions, but they publish it. Because number one, they do not have the time to go for, they do not have to file a patent. It takes a lot of time. And for the promotions, it is the publications which are more important rather than the patents. One can just bypass patents, still get promotion. And getting a publication is much easier than having a patent. Okay, so these are the things why scientists, they prefer going for publication, but this is, publication is good for oneself, but it is not good for the nation. Generally, invention which has been either published or publicly displayed cannot be patented, as the claimed invention will lose the novelty criteria. Novelty means what? It should not be existing in the public domain. But there are under certain circumstances, the Patent Act provides a grace period of 12 months for filing of a patent application from the date of its publication in a journal or an exhibition. Now, if you have published your work in some leading societies, journals offered by leading societies, you have delivered a talk in some in these societies, or you participate in exhibitions, you talked about these inventions, then exceptions can be made, but within 12 months of your making your invention public, you've got to file the patent, file the application for patent. But I would still suggest you don't have to wait to get the grant of a patent, then you can publish. No, you just have to file it, get a priority date. We'll talk about it later on what is priority date. And then if this takes just 4 or 5 months, this can be done, and then you can publish it. Now, can I discuss details of my invention with a potential investor before filing a patent? See, what happens is, like you have an invention, you have invented something, and you have filed for the patent application, but you want to sell it. Okay. Now, the selling is what should be the amount which you are asking. That would depend on the quality of your innovation, quality of your invention, and what are the steps involved in that. how much this will cost the person who is going to buy your patent or invention, right? So in that case, you don't have a patent as yet. You want to, but you have to disclose each and everything. Only then that person would decide whether to buy it or not, and if he's buying it at what cost. So what the person can do in this situation is they should go for non-disclosure agreement, a confidentiality agreement. You can sign that, and then you can divulge all this. So if there's some infringement of non-disclosure agreement by the buyer, you can take him to court. Okay, next is what kind of inventions can be protected? Patents can be granted for inventions in any field ranging from everyday kitchen utensil to a nanotechnology chip. You don't have to do a rocket science to get a patent. Even a small thing can give you patent, and you can earn good amount of money on it. I'll just give you a small example. One example. You look at this bottle of Coca-Cola. You look at this how to open it. This can opener, normally in the bottles, what you have is there's a cap. You just throw it with a cap, which is not good. So this is something like you can open the can, but this lid will remain attached to it. So the person who invented it, he has got millions of dollars. You can check in the Google how much money he has made on this. So it's a very small invention, but dividends are very high. Okay, invention can be a product, a chemical compound, or the complete process. Many products, in fact, contain a number of inventions. Like, yes, so you have one gadget, it might comprise of number of inventions. Like your laptop computer can involve hundreds of inventions which are working together. What types of inventions are not patentable? There's something on my screen, so I find it difficult to read. Okay, so there are certain inventions which are beyond the ambit of patents. Patents will not be granted. I'll just give you a few examples. Invention contrary to the public morality, like method of human cloning. So gene cloning is not a difficult thing. Tom, Dick, and Harry, anybody can do it. A graduate student in biology can do it now. Okay, so yes, we can clone some plants, we can clone certain microbes, genetically modified, but cloning a human is not allowed. Method of gambling is not allowed. Mere discovery of a thing, forming just a new organism which occurs freely in nature, laws of gravity not covered under patents. Mere discovery of a new form of a known substance. So, for example, use of aspirin for heart treatment. So aspirin is used as a painkiller, but now you have found another property, so it's very difficult to get a patent on that. Frivolous inventions, a dough containing certain herbs, merely changing the taste of the dough, 100-year calendar, bus timetable, these are non-patentable items. Arrangement or rearrangement, an umbrella fitted with a fan, torch attached to a bucket, non-patentable. Traditional knowledge, this we all Indians know about it. Basmati rice, this haldi. Antiseptic properties of turmeric for wound healing, pesticide and antiseptic properties of neem. So these are well known for thousands of years in India, right? So these comes under traditional knowledge, which is also a type of intellectual property. Invention relating to atomic energy, invention relating to compounds like uranium, radium, plutonium, which you can make these hydrogen bombs, these atom bombs, not allowed for patenting. Okay. Now, next slide is, do I need to file a patent in India? Before this, one must remember that patent is a territorial right. What does it mean? That if I have to exploit a patent in India, I'll file a patent in India. Now, if I want to exploit my patent in other countries, say like England, then I have to file a patent in England, France, Germany. So wherever I want to have the rights, I have to file a patent. Okay. So if you are an Indian, you have done something, you got a patent here, now you want to file a patent outside, but for that, you have to have a clearance from the Indian Patent Office. Okay, they will look at it. Only then they will see whether you are permitted or not. Now, sometimes what happens in certain cases, you develop an invention by interacting with a lab which is, say, in US. So one part of invention was done in US, other part was done in India, and you have applied for the patent. So, but you find that that patent has more value in US, it has got little value in India, or it may be vice versa. So in those scenarios, so the Indian Patent Office can give you a waiver to file first in other country. Okay, prominent international treaties and organizations. So I'll just talk about only the first two ones. See, what happens is each and every country has the laws, acts, and they, depending on their suitability, they devise the laws. But like you want to file here, you want to file in US, so then there can be some contradictions, especially when you have these two partners. So to normalize these things, to bring some uniformity in the patent laws and regulations in the rules, so United Nations has set aside established a dedicated agency, which is known as WIPO, World Intellectual Property Organization. So this is based in Geneva, headquarters in Geneva. Its purpose is to promote and protect IP worldwide and to ensure administrative cooperation among the IP unions established by the treaties. So by and large, all countries, close to like 190, they are members of the WIPO. Now, WIPO has involved in setting up, in the creation of many treaties. I'll just talk about one treaty. These are international treaties. That is a PCT, Patent Cooperation Treaty, PCT, 1970 was established. It's an international treaty which provides a unified procedure for filing patent application to protect inventions in each of its contracting countries. So what we are saying here is, now, as I told you earlier, so as they are territorial rights, so you got to file your patents in different countries. So this can be very cumbersome, very time consuming also, right? So, and then you cannot go to each and every country, then you have to find a patent on. So what the WIPO has done it, so they, under this treaty, you just file one patent, one application, sorry, and that application is applicable in all the countries. It is very expensive when there's so many countries are involved. But there are other treaties also which are regional treaties for Europe, or only for Europe, only for Africa. These kind of treaties also exist. So this is a little bit I just wanted to share about the international treaties and organizations. Now, these are some of the terms which are often used for filing a patent: inventor, applicant, patentee, license, enforce, assignee. This, in case somebody wants it, I can give you the details of it because I think I don't want to spend too much time on this. So I'll just skip these, priority art, all these things. Okay, so just on the lighter side now, I'll just show you some data about the patents. So what we have here is top 5 prolific inventors of the world. Just look at, there is one scientist, Shunpei Yamazaki. He has over 5,000 patents to his name, Japanese. And he has this much of patents. He got these patents during a period of 49 years, starting with 72 to 2020. He's still active. So this fellow is amazing. He's generating 115 patents per year. There is another poor scientist, Kia Silverbrook from Australia. He is generating 190 patents per year. Okay, so her total number is less because she just started in 1994. She looks very young. So I mean, it's mind-boggling. How can you have so many patents? So I was just curious. My colleagues and myself were curious. What's the situation of Indians? So we dig out some data, and what we found is Indians are not doing that bad. So here is the name of Gurtesh Sandhu, Devendra Sedana, and others. They are of Indian origin, but all of them are right now in US. They're working with different companies, and that on the top of the list is Gurtesh Sandhu. He's got over 1,300 patents. In a span of 30 years, he's generated 45 patents per year, which is creditable, too much number. Okay, now, as Government of India is popularizing information, these IP, intellectual property, especially patents. So what they are doing is they have come up with a policy, which came out in 2016. This policy talks about rules and regulations and how to publicize, how to enhance the awareness of the IP system in India. So we need people, a number of experts are very less. So there are some institutes which are offering some very good courses in IPR. I just named a few of them: Rajiv Gandhi National Institute of IP Management, Indira Gandhi, and this is started by the Ministry of Commerce, Indira Gandhi National Open University, IIT Kharagpur, NELSR, FICCI, Tamil Nadu, and WIPO. So, I mean, just you type these words in the Google, you can get more information. But there is an organization in India by the name TIFAC, which has started a scheme of late for the women scientists. That scheme is known as Kiran IPR, Knowledge Involvement in Research Advancement Through Nurturing. Kiran IPR scheme. It aims at mainstreaming the women having qualification in science and technology. जो ladies थी उनको science and technology के बाद they got married for some other reasons, they had to take a break. Now they want to get back into the science stream. So उनके लिए ये scheme start की गई है. It prepares them towards self-employment by providing on-job training in the area of IPR. It's a one-year program open to women scientists. So just type TIFAC Kiran scheme, like you can get all information. Now, if you look at the scenario of patent applications by some Asian countries, that's a data we collected from the WIPO site. What you look at, if you look at the rankings, China is number 1, Japan 3rd, Korea 4th, India 7th, not bad, Singapore 17th. But the disturbing thing is, if you look at the total number of applications, patent applications which have been filed in the year 2019. China filed over 13 lakhs, South Korea over 2 lakhs, Japan over 3 lakhs, but India filed only 46,582. 46,000 only. Now, amongst these, there's a breakaway. There are two categories. We can divide all these patent applications into two: residents, that is by the Indians, and non-resident, they're the foreigners. Scientists, their companies, those who have filed patent applications in India. You look at nearly 68% of these 46,000 patent applications, they have been filed by non-residents. Whereas only Indians filed only 14,000, say like 15,000 patents. This number is very, very low. When you look at it, there are over 1,000 universities. There are over 600 reputed national research laboratories in India. There are so many, close to like 100 autonomous institutes set up by Ministry, MHRD. This number is very, very low. Right? So we don't have time. In case during the question time, I can answer what is happening and what can be done to improve this. Our central policy is mandated for these kind of recommendations. Okay. Now, our center compiled the data of the patents filed from 2010 onwards in India. Year-wise trend of patents, you can see the patents profile here from 39,000 to 47,000. But look at the after the filed patents granted. The green line is a patent granted, okay, which is very, very less. Okay, there's patent examines, this one. Let me take you to another study which we have carried out. Okay, now let's see the scenario, the patents which have been granted. That means the patents which have been granted, they should be commercialized. The patent has a value only then when you can sell it or when industry uses it, exploits it. And the selling of a patent is known as the patent has worked. Okay? When your patent granted, it has been sold, we call it as a working of a patent. Patent force means that once you have been granted a patent, every year you have to submit a nominal fee to keep it alive, right? So it's not that once it's been granted, so you get to use it, monopolize it without paying some annual fee. So that has to be paid to the office. When you pay that fee, your patent remains active. And how do you come to know that patent is active? Is every year the patent, or the patentee we call it, he has to file a form and submit to patent office, which is known as Form 27. That tells whether the patent has been worked or not. Okay, so what you find is the patents, the black line gives you an idea from 2010 onwards. The patent in force, the number is increasing. In 2007 or 2007, it took a dip. Forms filled. Filling of this form is mandatory. They have to do that. But look, till 2012, the number of forms filled is very, very low. They can be taken to court. But the government decided for some reasons not to take them to court. They did not fill the form. Okay? But then 2000 onwards, government became serious. So you see the number of forms filled. But look at this scenario. How many of these patents have been worked, have been licensed out, have been sold to the country? Again, the number is very less. You can see just 215 in 205 into 2018. So this is a very grim situation what we are facing. So our center has also carried out another study. We have published a book on the patents and applications of over 1,000 institutions of India for the patents and publications. This was released in 2017 by Honorable Minister of Science and Technology, Dr. Harshvardhan Ji, on Technology Day. So just to give you a glimpse, we wanted to find out how many institutes in India are doing good in publications as well as good in generating patents. Study the system, why is it so, and implement that system in the institutions which are good in publications but low on patents granted. So I'm not showing you data just for lack of time. So there are hundreds of tables we have it, but this is the study which has been very well appreciated, not by India, by other countries, including US. Our book has been highly appreciated there. The patents I just wanted to share with you. Next, we talk about copyrights and related rights. So as told you earlier, rights given by the law to the creator of the work in the field of, so when you say work in the field of literature and computer science, this comes under the ambit of copyrights. So if the work is in the domains of dramatics, sound recording, film, video recording, artistic, musical, this comes under the domain of related rights. Now, all these rights, they have been classified into various classes. Briefly, when we say it's a class of copyrights in the class literature, what do you mean? Books, essays, lectures, research articles, oral speeches, computer programs, software. Because computer program softwares, they are also are being thought of as languages. Then you have dramatics, screenplays and dramas, sound recordings, like whatever is on the phonogram and the CD-ROMs. Artistic, any drawing, painting, logo, map, chart, photographs, work of architecture, engravings, craftsmanships, they come under the class artistic or copyrights. Musical. What we have here is the musical notations, only the notes how the music has been created. It does not include any words or any action intended to be sung, spoken, or performed with the music. Okay? Then you have last category, cinematograph films. any work of visual recording, maybe your motion pictures, maybe TV programs, maybe your video recording, maybe sound recordings, they come under cinematography. Okay. Now, in the artistic, I used one word, photograph. So the copyright of a photographer goes to the person who clicks the photo, right? The photographer will get the copyrights. But a very interesting case came up in 2011. Some of you might have, because this was all in the newspapers and the media, you might be knowing it. So it's a case which was in the court, David versus Macaws. It's a monkey in Indonesia. In 2011, a UK-based photographer, David Slater, put his camera on tripod in the wildlife sanctuary to click the photograph of the macaw, this monkey. Okay? But what happened, this monkey got curious. He put his face in front of the camera and clicked the selfie. The monkey clicked selfie photograph, which became very famous. And with the result, it became legally controversial also. So then who owns the copyright now? Copyright goes to the person who clicked the photo. Okay? So now here, the monkey has clicked the photo. So what happened is, but there was a settlement, out of court settlement. And the settlement said, photographer will hold the copyright of the picture, but the photographer will pay 25% of the royalty share with the wildlife sanctuary where the monkey lives. Okay, so this was something I just wanted to share with you. So Copyright Acts came in 1957. The Act provides bundle of rights, including the rights of reproduction, communication to the public, translation of the work, adaptation. Translation means if it is in English, you translate it into other languages. Adaptation means is you have written a story or a book that's adapted in the form of a movie or a drama. Now, one term which is very important is the author in from the copyright point of view. So author is an individual who develops the content. Article or a book writer is the author. Musical work, composer is the author. For photos, photographer is the author. Software, computer programmer is the author. Cinematographic film and sound recordings, producer is the author. We'll talk about it. Okay. Now, there can be multiple holders of a copyright. There can be more than one copyright holders for a work. I'll just give you an example. Suppose you have a musical sound recording. A musical sound recording can have many right holders. The lyricist who wrote the lyrics, composer who wrote the music, singer who sang the song, musicians who perform the background music, and the person or the company who produced the sound recording. So one work can give you many copyright holders. It can be claimed by many copyright holders. Now, what is the criteria to qualify to get copyright protection? First is the work must be in some physical form. The physical form is intangible so that we can see it. We can hear it. Duration of existence can be very short period to a number of years. Duration may be just for a minute. Virtually any form of expression which can be viewed or listened qualifies as a copyright. Hurriedly scribbled notes of an impromptu speech is considered a copyrightable material. The work has to be original. The copyright work has to be expressed by the creator in his own frame of thoughts. Authors created it from independent thinking, void of duplication. Yes, you can get an idea which is already there established, but you got to express in your own thoughts. So for example, what I'm doing right now is I'm making a presentation on patents and copyright on IPRs. Okay, data is already available. So I looked at the data, but I expressed it in my own. Some of the things we just copied, right? So as a matter of fact, we can be taken to court for these things. But there are certain exceptions. And those exceptions we are using. Once I'm complete this copyright, then probably you'll understand what I'm saying. But otherwise, like the photograph of the macaw which I'm using, Coca-Cola, all these things, one has to take a permission. We did not, and probably once I'm finished, you'll understand the reason behind that. Okay. the work which you have created may appear similar to already existing works, but should not be the same. It may lack in quantity or quality or aesthetic merit. It will still pass the test of copyrightable work. The third criteria is the work has to be creative. The work must show at least some creative effort on the part of the author. Now, this is it's not clear-cut thing, a creative thing. There is no minimal limit for the extent of creativeness. It's a very subjective matter. Mere changing the dimensions of a book will not be granted copyright protection. An address book of alphabetically arranged telephone numbers does not qualify for copyright protection. Yes, but if you write this book alphabetically and you have the complete addresses, then you can opt for, you have the profession of that person, then you can go for a copyright. The person, okay, who are the owners of the copyright? The person who created the work is the first owner of the copyright. In case the author is an employee, has been employed by a private firm, the owner of the copyright shall be the proprietor of that firm. Government will be the primary owner of the government work in the absence of any kind of arrangement. The person delivering a speech is the first owner of the copyright. Now, what are the copyrights of the author? The rights which are given by the acts, by the law. So we can divide these rights into two, like the economic rights and the moral rights. Economic rights, they allow the rights owners to derive financial reward from the use of their works by others. Moral rights are further divided into two categories, the right of paternity and right of integrity. The right of paternity says, even if the copyright has been licensed to another party, the original author of the work retains the right to claim authorship of a work. So, for example, an author has the right to have the name on the cover of their book, even if they have assigned a copyright. So normally what we do in the universities is when we write an article, research article, or we publish it in the form of a book, we sell the rights to the book. In return, we get the royalty. Okay? But still, that book has to carry our name. That article has to carry our name. This is what we mean by right of paternity. Okay, right of integrity. The original author has a right to prevent misuse of the work, alterations, addition, deletions in the work resulting in misrepresentation of the said work, causing harm to the owner. Yes. So you sold the right to somebody, but he has started distorting what you wanted to convey in your article. Okay? If that doesn't go with the tune of your thoughts or what you wanted to convey, then you can challenge that person. This is your right of integrity. Okay, so the common infringements which we come across for the copyright, the commonly known acts involving infringement of copyrights are making copies for sale or hire, translating a work without permission of the copyright owner, importation and public exhibition of infringing copies into India, bahar se, when you have this material which is infringed. Copyright infringement is a criminal offense. As per the section 63 of the Copyright Act, minimum punishment can be your 6 months with minimum fine of rupees 50,000. This can, in your subsequent conviction, these can go up to, period can go up to 1 year and a fine up to 1 lakh. Now, there are no dedicated courts for these copyrights. District court concerned has the jurisdiction in civil suits regarding the copyright infringements. There is a copyright board to adjudicate certain cases pertaining to copyright which are not of serious nature. This can be tackled by this board. Now, there is a common term which is used in the copyright world, that is fair use doctrine. Anybody with copyright should know this thing. This doctrine, what it says is, any person not possessing a valid license from the owner of the copyright is not entitled to exploit the said work. Okay, we know this thing. However, the Copyright Act 1917 and the section 52 says there are certain exceptions to this infringement. These exceptions are known as fair use of doctrine, which have been mentioned in the Act, and I'll just mention a few exceptions. If the copyright work is used for personal use, like I'm a teacher, I can use it for studies, teaching, or research. Quotations mentioned in the copyright work, reporting of current works, current events in the media, performance free of charge by government officials in the performance of their duties, that is, reproduction of any work for the purpose of judicial proceedings, reproduction or publication of any work prepared by a secretariat of a legislature, making of not more than 3 copies of a book in non-commercial public library for the use of library, if such books are not available in India. And lastly, which is also quite important for us, bona fide religious ceremonies, including marriage functions. Okay, here one can use copyright material. Now, in the era of this internet, so I just want you to know what does the copyrights they have to say about this internet thing. There's a growing concern about the ability to pull copyrighted material from the internet without permission. In general, posting material on the internet by the copyright owner gives an internet user the right to use that material for his or her own personal use only. It does not necessarily give the user the right to redistribute that material for commercial purpose. Okay? So you can download it for your purpose, but you cannot use it. You can exploit it. Electronic distribution of a copyright work should stay. The work is protected by copyright laws and is provided for educational instruction only. So it is recommended that your copyright work should have the sentence. Okay, just like a non-patentable thing, there are some non-copyright work. Examples I'll give you. Copyright does not cover the ideas and concepts. It's only the form in which they are expressed. Facts such as scientific or historical discoveries are not copyrighted. So what do you mean by this? So like any fact a person discovers in the course of research cannot be copyright protected. For example, an author of a book on Buddhism takes 10 to 15 years to gather historical facts. He publishes a book. Okay. Now, anyone is free, once a book is there, those facts have been mentioned, anyone is free to use the underlying facts provided they express the information in their own words. So the person like who gathered these facts, okay, he doesn't get any copyright on that only he can use. Copyright does not protect titles, names, slogans, short phrases, short word combinations, methods, or factual information. Certificates are not considered copyright subject matter as there is not much scope of creativity. Copyright registration for a website as a whole is not possible. However, different components of a website can be granted copyright registration. So what we have in the computer is computer programs, which can be covered by literary works, photographs, paintings, diagrams, charts, etc., artistic works, musical works under sound recordings, and cinematographic films. So these components are copyrighted. Okay, now, how do you go for the copyright registration? And before that, one must know, it is very important, copyright is not necessarily, to have a copyright, it is not necessary to register a work to claim a copyright. Unlike patents, I repeat, it is not necessary to register a work to claim a copyright. Once a work has been created, it receives an automatic copyright safety. Copyright registration does not confer any rights. It is merely a proof of an entry in respect of the work in the copyright register. But this thing becomes important. The certificate of registration of copyright serves as a prima facie evidence in the court of law. If somebody drags you to court, then it becomes important. It is admissible that the author of the work registered for copyright for better legal protection. There's not much money involved, much fee is involved also. So for copyright registration, the whole process takes around 2 to 3 months to get the work registered by the Copyright Office. After filing the application, there is mandatory waiting period of 30 days. So your copyright material is displayed in the public, so any can read it, and Any doubts, everything is cleared within this period. Any person has any objection to the claims made in the application, he can contact the office of the Registrar of Copyrights. After giving an opportunity of hearing to both the parties, the registrar may decide the case in favor or against the author of the work. Once the objections are cleared, the application is evaluated by the examiners. If any doubts, queries are raised by the examiner, the applicant is given ample time to clear these objections. Only after that, copyright is granted. Now, normally, simple.
Sir, sorry to interrupt, sir, but we have a few questions coming up, and the slides are going on, and you might have to go back. So, would you like to answer in the middle of the session, or would you like to answer towards the end?
Let me finish in like 5 to 10 minutes. I want to.
Okay, sir.
Okay, all right.
Okay, sir.
Okay, this is done. So these are copyright symbols which you often find small letters C in a circle, copyright or this thing. For phonograms, one can write P. Validity of the copyright is in general the lifetime of the author plus 60 years. For literally dramatic musical artists, where 60-year period is counted from the year of the following death of the author. Okay, now look at this. Amitabh Bachchan to lose copyrights over his father's works in 2063. We know Amitabh Bachchan's father was a great poet, Shri Harivansh Rai Bachchanji, and Amitabh Bachchan often quotes from the poems written by Harivansh Rai Bachchanji. So he has the copyrights. So copyrights, they go beyond 60 years beyond the death of the person. So in 2063, Amitabh Bachchan or his family, they will lose the copyrights. Publish, we can skip this. Transfer of copyrights. Okay, so usually the authors transfer their rights to the publishers for financial benefits. Transferring copyright unconditionally to the publishers may have some repercussions for the owner of the copyright. For example, publisher may prevent scientists to display their articles on the website. This happens in Stanford University. Also may not even allow the authors revise their work. Generally, we tend to revise, we teachers. But then once we have completely given our copyrights to somebody, it becomes difficult. Alternative is do not transfer all the copyrights. An agreement may be signed permitting only print and sale of the hard copies by the publisher while retaining the digital rights for the said work. Authors may also put time limit for printing and sale of the books. I mean, there are a number of ways and you can go about these things. Okay. Now, since copyright like patent is very, very complicated, a professor who has so many other responsibilities, he may not be in a position to take care of the copyrights. So there are copyright societies approved by the government. They have come up and they take care of all the logistics in terms of keeping the track of all the rights and infringements related to their clients. They can issue licenses also. They can collect fees from the ones to whom you have sold your rights. So the names are just listed here. Okay, so this was my last slide. So thank you very much, all of you, for your patient listening. Listening. And before I conclude, I must thank DPI IT, Ministry of Commerce and Industry, those who have constituted this IPR chair here, and DST, the scientists of DST Center for Policy Research, Ms. Mamta Bhardwaj and Mrs. Sukriti Paliwal. So Mamta is, both are sitting with me here. Mamta is really an expert in the domain of patents. All the data, what we showed you, the patent publications. So this has been generated by Mamta and myself. So Sukriti is our IT expert. So she helps us in many ways, including making the PPTs. So thank you very much. So I'll welcome if there are any questions now.
Thank you, sir. It is very interesting topic, especially when in this scenario, everyone is trying to, write something or make something of their own. But before we conclude, sir, a few questions for you. I will read out the questions. One is from Mr. Vijendra Bhala. He says that if there is an add-on to a patent filed by you in terms of newer, entirely different application, how to secure that? Can it be done through by addition to previous, or do we need to file a new patent?
There is a term known as patent of addition. Okay, so incidentally, Bhalla is my student. And then you come to me, that then we can talk in detail about it. Okay, so one should first look into the patent addition, which is especially when you have done some incremental improvements. So you don't have to file a new patent application. So get to that. So there is less money involved in this, and the process will take.
Okay, thank you, sir. Then one question is, what does one have to do for a career in IPR? And this is from Dr. Lav Singh. And related to this is Ms. Palak Jam's question. Is there any online course which can be suggested by you for learning about IPR in healthcare? So 2 questions.
Yes.
Career in IPR and one about IPR in healthcare.
Yes. It's a question which briefly I mentioned in one of my slides. The course is offered by. So what they can do is they just type WIPO. So WIPO IPR courses, they'll get a lot of material in that. Then there is a Rajiv Gandhi National Institute in Nagpur, which Government of India has dedicated, created for IP courses. There are some IITs who are running courses. Indira Gandhi National University is also running courses. So you just type it on the Google, you can get a whole list. If you want something more on that, just type a word TIFAC, TIFAC, Technology Information Forecasting, something like that. So it's in New Delhi office. So they are the ones who are running one course for women scientists by the name Kiran, which I just mentioned. And probably they can, if you have just get onto that site and see if there's some more information available over there.
Okay, sir. Thank you.
Which people prefer. So they have a number of courses, starting with the very introductory courses and advanced courses.
Sir, thank you. Next question is a little different. It says, sir, mere filing of patents, does it add up to your CV for grant, or granting of patent is only useful? Like many people file patents but are not granted all of them. Does this patent filing help them whether they are granted or not?
I got the point. Let me answer this one. Okay. See, patent filing is not difficult, but grant of a patent in India takes a lot of time, maybe like 3 years, 4 years, maybe more than that in general, right? So, if you just file it, you just write on your CV. There may be some marks, I do not know now, to just a filing, but definitely patent granted will give you a lot of things. But what happens is, in case your patent file has a value, right? You don't have to wait for the patent granted to be licensed, to be sold. Once you have filed an application, okay, you can sell your invention. Okay, now that you have filed and you have sold it to an industry or to anybody, so this would carry a lot of weightage. Even if there is no special call for the marks, but when we go for judging people, for interviewing people, we can find ways and means how to compensate for that if there is no special column. Right? So this will definitely help. This will definitely help even if you have filed it. Just mere filing, and you say you have filed it for the last 1 year or 2 years, then the question would be, why was you not able to license it? Right? But if you have filed it and you have just, it's only 1 or 2 months, then people might say, okay, so it's only 2 months. So probably I answered this question. It's not new to me, but yet there is a dilemma also how to put it across in the performance evaluation for promotions.
Yes, sir, we understood it now. Sir, another question from Mr. Pawan Sharma is, Could you please elaborate role of recent amendment act, a recent amendment in Copyright Act, specifically broadcasting rights?
No, I am totally incompetent in these things. So as I told you, like I'm also learning the copyrights and the patents, but I'm not gone into the details. So this responsibility of patents, I'm not an expert on patents, but I've been working on the patent from different aspects. That's why this chair has been given. But this amendments, one can easily just get it onto this copyright office, which is under the DPIIT, Office of Control. Just type DPIIT, the copyright, so you will get the information over there. Of all the amendments, everything is there on that site.
And sir, he is asking same question. Participant, Mr. Pavan Sharma, is also asking that on your slide number 35, you'll have to go back to that slide. I think possible reasons and dip in the Form 27 filing is. Can you?
Yes. There was dip. See, this is what I'm saying. I've been in touch with the patent office. When you are granted a patent, every year you have to inform the patent office whether you have licensed the patent or not, right? And this is done in the way of filling this Form 27. So you have to tell, like, if it is sold, to whom you have sold it, if it is not sold, what efforts you have made. So things like that mentioned in there. And it is mandatory. But the IPO office, when the patent thing is, their reason was, so when I talked to the joint controller in the patent office in Dwarka, so their reason was, sir, in case we become so harsh, there are very small number of people who are patenting, very small people who are getting patents granted. And if you put a penalty on them, then they'll be just put off. So knowingly that it is mandatory, but they were kind of like just keeping their eyes away from that. They didn't want to push too hard.
Thank you, sir. One last question. This is from Mr. Rajan Bateja. Is it true that emailing the work to yourself gives you a valid copyright? If no, where to apply for the valid copyright?
No, I didn't get it. Like, so you email to yourself.
Sir, even I didn't understand the question. I'll read it again.
Mm-hmm.
Is it true that emailing the work to yourself gives you a valid copyright? If no, where to apply for the valid copyright?
No, if it is your own work, no, I didn't get it. Like, so for getting a copyright, you don't have to submit any form, as they mentioned it. Okay, so this is the moment you put it in the public domain, you wrote something, you put it in the public domain, you have a copyright on that. It's automatic.
Okay. Sir, that is all the questions, and I think we are running out of time also now. So we will wrap it up, and I would like to thank you, sir, on behalf of PUK and all our participants. Sir, we thank you for sharing your knowledge with us, and we know that you have a very busy schedule, and we are grateful to you that you took out time for us for this important topic, especially in the present scenario, as you know, things have changed and new inventions are coming up, new businesses are coming up, and the knowledge of IP is very important for us. Even I am writing something, so knowing that how to go about it was helpful, and I made notes.
Good.
And thank you once again, sir, for
So,
doing this.
Sonia, just before you close down, I
Yes,
must thank all of you, especially Professor Deepthi Gupta, for
Yes,
arranging
sir.
this lecture. And incidentally, this is my first or second lecture on IPR. I'm just trying to understand the things. So we are writing some small articles so that will give me a grasp of the IPR. So thank you very much for putting some pressure on me to make a presentation. And for the last 3-4 days, I could gather, hopefully, listeners, they were satisfied with my talk. Thank you very much.
So Deepti ma'am is also thanking you. She can't unmute herself right now. And I also want to thank the audience. You've been very disciplined and for interesting questions that you have given. And we hope to see you in our next webinar on 11th July. That's the World Population Day, same time, 11 o'clock. And we'll be sharing the webinar details with you through posters and messages. Thank you, Rupinder sir.
Thank you very much. Thank you. Thank you. Bye-bye.
Yes. Bye, sir. Thank you, everyone.